Honorable the representatives of the AU delegation to Vietnam and Honorable representative of the delegation to Thailand, ladies and gentlemen, we deem that IP is very important, state management, and given the issuance of the revised law in 2022, we can say that the legal system on IP of Vietnam has been relatively sufficient, meeting at least the requirements of reality so far, and also meeting the implementation of Vietnam's commitments within the framework of international conventions ratified by Vietnam, especially the high standards in FTAs that the country has been a signatory of, for example, EVFTA, CPTPP. As Master of Ceremony has mentioned earlier, the targets of the revised law on IP was aimed at institutionalizing the views, the orientation of the state of Vietnam, considering IP a motive force, an important motive force, a tool for the socio-economic development, as well as to serve the innovation, creativity and innovation, which has been given great attention to so far, and also to overcome the limitations realized, seen, observed after its the previous version implemented, and also last but not least to domesticate, to codify the commitments into Vietnamese legislation. What we have committed with the world, including EVFTA, on the 23rd of August, the government issued decree number 23, number 65. Yeah, sorry. Decree number 65, dated 23rd of August, detailing the stipulations and the measures to implement the revised law of IP 2022. Officially called that the law on revisions and amendments and supplements to the IP law. And we are working to guide the implementation of decree number 65 and IP laws legislation. We hope that not later than early October or maybe in later September, we will issue a circular guiding the implementation of Decree 65 on industrial trademark and properties. And for the copyright, the circular has already been implemented, and the decree on plant varieties is being awaited. That is a development of related legislations or documents. However, they are only pieces of paper. If we fail to carry out effectively, including the competent authorities and also the stakeholders should be informed, or they will be informing, disseminating to the right holders, and organize the serious implementation of the regulations. No matter how perfect the regulations are, given the fast development of science and technology and social relationships, we can keep changing the explanation and the implementation in a most appropriate manner. Stay vital. Given that awareness today, with the value and supports of the IP key Southeast Asia, we from IP Office of Vietnam are co-organizing with a project to organize a seminar on IP legislation, change to promote creativity and innovation. We hope that the speakers will provide to you with the contents related to the law on amendments and supplements to the IP law, and then we can discuss issues in the law as well as what is happening in reality. We are hopeful to receive the active participation from you all. We will have a one-day seminar. And I hope also that it will be useful for all parties, including the state management agencies or regulators, which draft legal documents and organizes the implementation, and also the businesses. We have the businesses here who are the beneficiaries of the legal documents on IP. We look forward to your participation, the active participation of you all. Once again, on behalf of the IP Office of Leader, we'd like to express our sincere thanks to the EU delegation to Vietnam, especially the IPK South Asia project, the experts of the project management unit participating today. We wish you the honorable representative of the EU delegation to Vietnam, EU delegation to Thailand, and you all, and the IPK projects, and everyone, good health, happiness, and success. Thank you.
Hello, and good morning to everybody. Today is a very important event that is just being opened by Director General Nguyen Van Bay here. I'm very pleased to be able to share some remarks. I myself, let me just quickly introduce, I'm not an IPR expert, and that is somehow good, and it's a shortcoming. It is also something that maybe the IPR sector very often suffers from. It's highly complex area which requires a lot of study before you are competent to work in this area, which also leads to the fact that mostly experts look into the area that we are discussing here today. Whereas it is very often completely underestimated the key importance that IPR protection has for the country's development. So just to myself, I'm Carsten, it's very easy. Carsten, like 10 cars the other way, Carsten. And I was sent here in 2019 to ensure the ratification of the EVFTA, and also, of course, the implementation of the EVFTA. And as you all know, the EVFTA has delivered enormous growth rates in our trade. Only last year, it grew by 30%, 32% to be exact, so almost a third. And actually, Vietnam is profiting much too much. We need to profit a little more on the European side, to be honest. But in this, of course, we are implementing the whole area of all aspects of the 17 chapters. But one key chapter that is mostly overlooked by politicians and also by trade persons is IPR. And so let me just share with you some personal reflections out of many years in working in these economic areas. So I would say there was once a chart, I'm not an expert, so I just saw it somewhere in my life, where you saw the economic development of Japan, the economic development of Korea, and the development of China, compared to the enforcement of IPR in the country. And there is such a clear relationship that there is no development to a high-income country if there is not big and strong enforcement on IPR. Now, I don't know which of the two comes first. You know, we speak in European language about the chicken and the egg. Is it that you need more development first to get more IPR protection, or is it actually more IPR enforcement to get more development? I think we need both at the same time, and they have to go a little hand in hand. To be honest, after almost 4 years here in Vietnam, I think the IPR protection on the ground, in the reality in Vietnam, has to be strengthened. To achieve what? To achieve the attraction of more foreign direct investment in high-tech sectors. You are not going to get IT, I know you have something and so on, but you want to do it yourself, right? And then you need Europeans because they share. We know that some of the others don't share their knowledge, but the Europeans always share and provide, how do you say, I'm an economist, positive externalities. So the benefits companies from Europe that invest here are given back to the country, and in different areas in a different way. Sometimes it can be a higher environmental protection, but here in this area, it may be actually more on-the-job know-how transfer, because it is what you really need is to have and create Vietnamese that are working in these high-tech companies so that you can move on in your development. So the IPR enforcement is a key factor for the attraction of this. So another one is innovation. There is no innovation if you don't have IPR working on the ground, being implied. So now, right now, the expenditure of Vietnam, I think, on innovation and research and development is roughly 0.54 of the GDP. I don't know whether that's enough or not. Maybe you should step it up. But in reality, what you can do, and it's almost for free, is step up the IPR framework application. Let me share a word with you of appreciation. We have very good development cooperation in the IPR field. In the EVFTA, actually, it's one of the few sectors where we have also a working group so that you can talk amongst experts and provide and exchange more. And when I arrived, I was told by my friends in MIT, we have already CPTPP, we don't need to do anything for the implementation of the EVFTA on IPR. And then in 2022, I was very happy to see that you changed your law in 134 articles to implement ours. But all my colleagues that understand this subject much better than me, or understand it together much better, are very happy. And I think the legislative framework that you put in place is all you need at this moment. Now, I've just learned actually that you have Decree 65, so I'm very happy to receive a copy of that, if possible in English, but because that is, of course, because we really need to look into that. I was talking about innovation. I've just received, and actually it was yesterday with the president that my new ambassador presented his credentials. Let me tell you that he was a director for Horizon Europe. Horizon Europe is the biggest, by far biggest, research project of the world. He was very much in charge of that. He was the boss of it. So I think that research and development will also become a much more important aspect of our bilateral relations, which means IPR will again be key to make sure that whatever you need, that in the digital transformation, artificial intelligence, to attract semiconductor industry, the very high level and industries that Vietnam is looking to attract and probably has a good chance of doing and attracting. The IPR application, again, is the key for that. So now I'm not talking about, I mean, IPR is important in every aspect of life. Of course, our luxury good producers and wines and spirits, GIs, all of these aspects that are not patent or copyright or trademark or design protection directly, well, some are designed in this list, but they are still also suffer from the enforcement. And I think that when it comes, it is mostly that they are still looking for a development of a more vibrant, more lively possibility to use courts to enforce their rights. And I think that the European Union in many projects, like this one here today, is also looking into helping the better education of judges, because it's a very specialized area. But you need lawyers, you need all of that, because if you want to move on from a middle income economy to a high middle income or even a high income economy, issues cannot be solved administratively only. So there's another very important aspect. Today you will have a very rich seminar, and I'm very happy that even though it was a little last minute that I was asked here to come, to be able to just provide a few remarks that all of you are aware of because you work in this area, but to bring it back also to the Vietnamese context, where I think that congratulations and thanks are due for the really good work that was done in promoting and adopting the new legislative framework. And at the same time, we enjoy a very good cooperation, like here today, to make sure that we can, in a way, assist or accompany Vietnam also on its way to achieve the broader political objectives of moving to a high-income economy, where, in my personal opinion, even though not an expert, as I say for the third time now, is the absolute must and the condition. So I have that habit of speaking too much and too long, and I thank you very much, all of you, for your attention. Thank you so much.
The presentation will have three parts. First one, the objective of the promulgation of the law and the guiding views for the drafting of the laws, and then secondly, the structure, the outline, and the main contents, and number three, the decrees issued to guide the implementation of the law. First, the objective of the issuance of law and the guiding views of its drafting, with expectation of rapidly integrate in the world, boosting the opening of the market, and also to exercise the commitment in the FTA. We aim to revise the law as a homogeneous, synchronous one to in line with the multilateral and bilateral agreements on IP law. The 2005 IP laws approved by the National Assembly was the fundamental law, helping Vietnam to officially becoming a member of WTO. And after 3 years of implementation, the IP law was revised for the first time in 2009, aimed at overcoming some of limitations arising from the reality and revising some stipulations which were not quite compliant with the international conventions like the Berne Convention, the UPOV, and the BTA between Vietnam and the US. And also the stipulations on IP protection for the second revision in 2019. It was a context of Vietnam integrating more and more broadly into the international economy for the period of 2010-2018, given the negotiating and signing of a series of FTAs, including those of new generations with partners, including key partners like Asia-Europe Economic Alliance, European Union, Japan, South Korea, China, Australia, especially the TPP and then the CPTPP. For the revision in 2019, it was mostly to revise and add with some stipulations to ensure meeting the obligations to be exercised immediately raised by CPTPP, which took effect in Vietnam on the 14th of January 2019. And for the third revision, with a series of commitments on IP in the period from 2010 to the later period. In 2019, Vietnam saw that at the meeting on the 16th of June 2022, in the third session of the 15th tenure of the National Assembly, it approved the third revision to the IP law, which took effect on the first day of 2023. The law amending and supplementing to a number of articles of IP law 2022 has 4 articles. Article number 1 mentioning the amending and supplementing of 102 articles of the IP laws, revising and supplementing 88 existing articles, added with 14 new articles, and removing 2 articles. On the second articles is stipulate about the revision to a number of other laws, law on customs, law on technology, law on pricing, law on the management and utilization of assets. The fundamental contents of the 2022 revised law was on 7 major policies. The first one is to ensure the clear stipulation on the author, the holder of the rights, performers, owner of the related laws in the cases of transferring of rights. The second policy is to encourage the creation and exploitation and registration of patents, industrial designs, the variety of plants. And policy number 3 is to facilitate the application process, registration process. Policy group number 4 are the regulations related to the ensuring the appropriate and balanced protection in IP protection. And policy group number 5 is to enhance the efficiency of the support activities on intellectual property. So these are the main contents of the revised law. And policy group number 6 is to enhance the efficiency of the protection activities, including the ensuring with the mechanisms to protect the IP rights. Group policy number 7 is to ensure the serious and sufficient implementation of international commitments. And the IP law, after being revised, put into practice for implementation, recently the government issued 2 decrees related to the copyrights, related rights, and industrial ownership rights. Namely decree number 65 on the 23rd of August 2023 of the government, detailing a number of articles and measures to carry out the IP law on industrial ownership, and also the right to plant varieties and state management on intellectual property. It took effect on the 23rd of August, the signing date it is. And it replaces partially all the decrees of 103 2006, decree number 105 2006, decree 119 2010, and decree number 122 of 2010, and decree 154 2018. They are replaced partially or wholly by decree 65. And on the copyright and related rights, the government also issued a decree number 17 on the 26th of April, which took effect also on that date. And it also replaces wholly or partially the previously issued decrees, namely decree number 22 2018, decree 105 2006, Decree 119 of 2010 of the government. As DDG 7 has mentioned, in the coming period, the government will issue the decree detailing a number of the stipulation on the domain of plant varieties. That is my briefing on the law amending and supplementing to a number of articles of the IP law. The revisions made in 2022 and also decrees. My colleagues will speak in more detail about the decrees. Thank you. In her presentation, I just want to say that among the 222 articles of the revised IP law, 102 of them have been revised, which means amended and supplemented. And for the copyright and related rights, 27 articles were revised and 7 articles were supplemented. And there were also some other articles in, for example, the law on pricing was also revised. The objectives and the instructing views, guiding views, Vietnam aim to handle the difficulties, challenges in implementing and also codifying into Vietnamese law the commitments made by Vietnam, including in EVFTA. For the domain of copyrights and related rights, we also revised, added 6 out of the 7 group of policies that Ms. Lien presented to you earlier. And accordingly, for the contents of copyright law, related laws, we made the revisions on the laws, the limitations, the exceptions, stipulation related to the registration of copyright law, related laws, and the content related to the collective representation and also stipulation on the infringements and the exercising or enforcement of the related rights and copyrights. In the first group, policy related to the right holders, we clearly specified the rights of the author, performers, manufacturers of records, and organizers of broadcastings, as well as stipulation related to the right holders of copyrights and related rights, as you can see on the slide. For the limitation and exceptions, we also revise a stipulation to ensure more clearly, to ensure that the individuals and organizations to be able to exercise, and on the basis of based on the principles to ensure the harmonized or balanced interest between the right holders and the users, as well as the consumers who are the public, in line with the process of a 3-step such trial principles as stated in the EVFTA and other related international conventions and agreements. For the collective representation, we stipulated so that such organizations shall be operated in a transparent manner to protect the legitimate rights and interests of the right holders, and also facilitate the exploitation and usage of companies, enterprises in using copyrights and related rights. In terms of the registration of the copyright related rights, we also revised to ensure the handling and approving the applications in an online, in an electronic manner, in line with the instruction of the government. And for the infringements, we have also redesigned that in the revised law, not listing specific behaviors, but we are geared, we are aimed toward the infringing activities, and we also added with new infringement activities on the cyberspace, on the digital environment. We have also legalized, turned into law the stipulation in the previous decrees. For example, adding the stipulation related to the legal liabilities of the intermediaries, the providers of intermediary services, in line with EVFTA, CPTPP, putting that into the revised IP law so that the intermediaries shall be responsible to cooperate with the competent state authorities, especially the right holders, in detecting and preventing infringements on the digital environment. In terms of, say, number of specific contents, in terms of the terminology, we have also added with the terminology, for example, the right management information, or the related technologies. So such terminology have been codified into Vietnamese law to ensure the commitment made in agreements like EVFTA. And for the rights, we also clearly define the right to perform artistically to the public, the right of distribution, and also to make the clarification on the copying law, right to copy, so that the copying shall also be in line with the law and on the under scope of governance of the law, the right to broadcast and disseminate the works to the public. I also stipulated to ensure WCPF, WPPP, and EVFTA agreements and the like. For the specific contents, you can read on the slide, but in a nutshell, for the contents of the rights, we have stipulated on them, and fundamentally, they are similar to the texts, the text in the EVFTA and CPTPP. Similarly, for the rights of the performers, we also have revised things to be in line with the copyrights and to be in line with the global the World Agreement on Recordings and Phonograms of WIPO, and also the right of the manufacturers of recordings in Article number 30. The rights of the broadcasters also are stipulated. We have revised, we have added with the stipulation on broadcasting, rebroadcasting, copying, recording, shaping the programs, or importing to distribute. The exceptions on copyrights and related rights, such stipulation have been revised in detail, especially the behaviors related to copying on the digital environment, to ensure the three-step trial principles, and also to serve the research purposes, scientific research by individuals. We stipulated qualitatively of rational copying, and with the specific guidance in decree number 17 of 2023. In that decree number 17, we try to quantify some behaviors. For example, allowing the copying using the copying devices, about 10% of the contents of the work. Similarly, in the education and scientific research, we also added with the activities of the state agencies. And in the domain of library, We also met the requirements of digitization and interoperability among libraries, for which we add some kind of exceptions allowing the libraries to keep or distribute the digital copies internally inside the libraries, asking the libraries to control the use inside their agency, inside their offices, the libraries. And similarly, in the press media activities, we also stipulate more clearly to serve the exploitation and of information and providing of information to the readers, to the audience, to the public. Especially from the um, uh, uh, limitation for the limits for the exception, we also added with the stipulation of Marrakesh agreement that we ratified in March, so to ensure that the people with poor eyesight, the vision impaired people can be facilitated of approaching the works in a format appropriate to them. Vision impaired people. And such above mentioned stipulations are based on and complying with the three-step test principles to ensure not in conflict with the proper exploitation and not infringing the legitimate rights and interests of the right holders. And to facilitate the vision impaired people, it is stipulated in article number 25A to facilitate them in accessing and using such works.
Liên quan đến
And related to the limits of copyrights, we redesigned article number 26, whereby we remove the difficulties by assigning the government to provide detailed instruction on the trade activities, according to which individuals and organizations do not have to ask for permission, but they need to pay royalties. Or the translation or copying the works in line with the annex of the Berne Convention that has been legalized to facilitate the individuals or the organizations if they do not ask for the permission or they cannot have the consensus with the right holders, the state can allow them to translate or copy the things for scientific research purposes in the teaching sessions or for individual purposes. The law also stipulates that in case the organizations or individuals cannot fight the right holders to ask for permissions and use, they can use the compulsory licensing mechanism issued by the government, paying some amount of money, and then the state regulators will forward the money to the right holders once the state management regulator identifies the identity of that right holders. Similarly, for the copyright rights, now speaking about related rights, we also revise some stipulations on exceptions to ensure that the exercising the implementation will be facilitated. And for this revision, we have asked and been accepted for the revision of the law on pricing, so that the government can issue the templates, the forms of royalty. So in case that the individuals and organizations fail to reach a consensus in line with Article number 26 and Article 33 of the law and Decree number 17, we have two annexes of the two templates, the two forms of level of payments, the amount of money, level of payments, of fees, of charges, royalties, if the individuals and organizations fail to reach the consensus. Now on the collective representations organizations, as I said earlier, to ensure that such organizations to operate in a transparent manner, and there are the mechanism for the government to intervene when such organizations and the users fail to agree with each other. We design in Decree number 17 the mechanisms on approving the template, the form of pricing I have mentioned, or the mechanism to handle the conflicts, handle the disputes, where are the cases where they cannot reach consensus, that will be submitted for the Ministry of Culture, Sport and Tourism to handle via an intermediary mechanism between the state, some competent organizations, and when necessary, a council can be established to counsel the Minister of Culture, Sport and Tourism to make the final decision.
So we also reaffirm that registration is not the thing to benefit from the copyrights. And once we have received the copyright certificates, then the stakeholders do not have to prove except the case there is the evidence for the vice versa. And in this additional procedure, it just want to confirm or ensures the additional rights. So for violations, we have redesigned it in a case that the violations of the personal rights and also assets has been regulated. So for the law 2015 and the amended law 2018, so this is to ensure it is the most sufficient to avoid the missing things and also the redundancy like in 2015. And it also stipulates the rights protection and copyright protection. And also the behaviors related to the responsibilities of the intermediary service provider. So the Article 189, we have revised the content related to rights of copyright protection technology, as well as the rights to request the removal of content on internet and cyberspace. So apart from the relevant government stakeholders, the rights holders can directly request the intermediary service provider to remove the infringement on cyberspace.
Liên quan đến giả định.
So regarding the copyrights and other relevant rights, we have also institutionalized them. So we have upgraded the Decree 105. And also we have also the commitment from EVFTA has been internalized into the Vietnam law IP system. So that is also consider the copyright holder as well as relevant rights, and we can conduct the prosecution of the civil rights in relevant cases.
Liên quan đến
So regarding the liabilities, regarding the copyrights and also other rights in relation to intermediary service providers, we have also regulated the types of enterprises and their responsibilities. So their responsibility is to implement technical measures and coordinate with relevant state government stakeholders and rights holders to protect the copyrights and other relevant rights. And also their responsibilities will be exempted if they comply with all regulations. And in case they don't implement it properly or they don't implement it adequately, they will be subject to liabilities related to copyright and other relevant rights. So in the law and also in the EVFTA, the intermediary service providers are exempted from legal liabilities if they only provide the access to the digital content. So in terms of storage, the digital content storage, they will be exempted from legal liabilities when they do not know that digital content infringe or violate the laws, or if they show their intention or their willingness of removing those digital content immediately after they detect that their digital content is a violation. So in Decree 177, we also have a clear explanation or definition about when it's considered or in what case it is considered that the intermediary service provider know the infringement. So for each case of receiving noticement on infringement on digital environment, the service provider, intermediary service provider have two different procedures to handle that. If they receive the notice from government stakeholders, so within 72 hours, they have to remove that infringing digital content. So in terms of receiving the notice from the rights holder, if they receive information or noticement from rights holder and also other evidence in the Decree 117, then they will temporarily remove that digital content, and within 10 days without any feedback, then intermediary service provider will remove infringing content. And in case there is feedback, the two sides has to meet with each other in person, and if it is necessary, that issue will be brought to the court for further handling. So for the buffer storage, the law has stipulated the conditions for exemption when the information is changed due to technology related reasons. So follow the principles on digital content update, and they are also responsible for removing the digital content and preventing the access to digital content if they is aware that that content has been removed from the initial or from the original source. Okay, so these are the three basic services provided by the intermediary service provider. So that has been put into this legal document. And also, in order to internalize EVFTA into our law system, we have also regulated the content on the exemption of legal liability. So in clause number 3, they do not have to look for evidence of violation. So all of these contents will have to come from the rights holder or from the users. Okay, so I have just presented the basic content on the updates of amended IP law 2012. So I'm very sorry that I am not able to provide more specific content regarding the Decree 117 2023, because at this decree, the government of Vietnam has put a detailed content to guide organization and individuals to implement it, especially regarding the rights holders on digital environment, cyberspace. Thank you very much for your attention.